Everybody, my name is SHIVAM MISHRA and I am advocate practice the Uttar Pradesh. Today I am going to discuss one of the most important concept in the criminal justice system, that is called the bail. About the bail, I can just only say that if you are going to make a career in the criminal litigation, then you must understand that concept, that your success rate is directly proportional to how quickly you got a bail in your favor from the court of law. So you need to become very prepared, you need to become very alert at the stage of bail. Why bail stage is very crucial and very important? Because in the criminal justice system, the trial is a very long journey. So bail is the stage where you can give a very quick relief to your accused person. So while you are arguing on the bail matter, you must consider some of the case laws. You must prepare, you must be advanced with the some of the fact, with some of the landmark judgments you can use while you are arguing on the matter of the bail. Why I am saying you need to become prepared? As we know that there is always public prosecutor is there who is ready to oppose your the bail application with the saying that सरकार अपराध बहुत गंभीर है, इनको बेल पे ना छोड़ा जाए, सरकार इनके पास एक लंबी क्रिमिनल हिस्ट्री है, सरकार अगर इनको बेल दे दिया जाएगा तो समाज के लिए एक गलत मैसेज जाएगा. लाइक एज दैट ग्राउंड द पब्लिक प्रोसिक्यूटर इज सेइंग for the opposing of the bail. So you need to become very alert, you need to become very advanced. When the public prosecutor says that अपराध बहुत गंभीर है, gravity of the offense, when the public prosecutor says for the deciding on the bail that the offense is very grievous in nature, that time you can use the judgment of the P. Chidambaram versus Directorate of Enforcement. I think that is decided by the A.S. Bopanna, Justice A.S. Bopanna and Justice R. Bhanumati, year 2019, 5 September 2019. This is the case P. Chidambaram versus Directorate of Enforcement, that is popularly known as the INX media cases, where the Supreme Court said that the gravity of the offences can be one consideration but cannot be solely consideration for denying the bail. And another very progressive judgment of the, I think that is Sanjay Chandra versus state versus CBI year 2020. That's a very recent case law. That's popularly known as the 2G cases, where the Justice G.S. Singhvi and the Justice H.L. Datto, both justice has clearly says that gravity may be one of the consideration but not solely. Again I am repeating both two judgment you can use when the public prosecutor is opposing your bail application by the gravity of the offences. That is the first case, that is known as the INX media cases, that is the P. Chidambaram versus Directorate of Enforcement, and another cases that is the Sanjay Chandra versus CBI year 2021. That is a very recent case law. I think that is decided 23 September 2021, and where the Supreme Court clearly say gravity may be one of the consideration but not can be solely. So you then use both judgment for getting the bail in your favor. And again when the public prosecutor says that सरकार अगर इनको बेल पे छोड़ दिया जाएगा तो ये समाज के लिए एक गलत मैसेज जाएगा, and that time you can use a very progressive judgment of by the Delhi High Court in the case of I think Firoz Khan versus State and City of Delhi year 2020. I think I'm not sure, but that is the 29 May 2020. If I'm wrong, then make me correct. But that is the judgment of Firoz Khan versus State and City of Delhi, where the High Court judge clearly says that courts are not there to send a message to the society. Court are here to decide bail with the settled principles. So you can use this judgment while the public prosecutor oppose your bail by saying that this will be go a wrongful message to society. The sum of the another ground that public prosecutor says that accused person have long criminal history, that time you can use a very landmark judgment of the Supreme Court by the Supreme Court, that's the Prabhakar Tiwari versus State of UP. That is decided in 24 January 2020. I am sharing the some of the recent judgment. You can always use in your pocket while you are arguing on the bail matter. Again I am repeating, criminal history, when the public prosecutor is opposing your bail by the criminal history, that time you can use this judgment where the justice in the bench of the Justice Deepak Gupta, Justice Anirudh Bose, and that they have been clearly says that criminal history factor by themselves cannot be basis for refusal of prayer for bail. So this judgment you can use in while the public prosecutor opposing your bail. These are the very landmark and very popular and well established judgment you can use while you are arguing on the bail matter. And be remember some of the keyword while you are arguing on the bail. I think in the 1977 the state of Rajasthan versus Balchand, that put as bail not jail, that is the bail is jail and jail is exception. This is a principle, that is the settled principles that Supreme Court have observed in year 1977 in the case of state of Rajasthan versus Balchand. And criminal justice system, the principle presumption of innocence is always